This is Bruce Wall from the City of Scottsdale's Neighborhood College Program. We're all in this together.
The City of Peoria. We're in this together.
The City of Chandler. We're in this together.
Hi, this is Jamie from the City of Scottsdale with my daughter Jocelyn. We're in this together.
City of Tempe. We are in this together. Thanks for being here today. The cities, the neighborhood services departments from the many cities that are sponsoring this class today appreciate you being here, and we hope you'll come to future classes. For those of you who are going to stay for the Q&A, let me tell you, this is usually the best time because we clarify questions that may have come up during the presentation, and maybe there's some new questions that aren't even on topic that we will continue to answer through the Q&A. So usually the Q&A takes about a half an hour. So just stay tuned. We're going to start right now. The first question is, do HOAs have any responsibility for barking dog complaints? So really good question. Actually, I was working on this yesterday. I'm updating all of our cheat sheets for 2021, and I was reading the one that we have on dog barking. So it really depends. So if you have a neighbor that has a barking dog that's causing a nuisance to other neighbors, the association, likely will have responsibility to intervene in some way. And so what we recommend is that a letter be sent to the owner with the barking dog, and that also you possibly reach out and talk to the owner about the issue, and hopefully that will solve it. If it doesn't, then you need to tell the complaining owner to document when the barking is occurring and to provide as much evidence as possible, even if it's a video of recording of the barking, and then escalate it to your legal counsel. Typically, the cities don't get too involved. City, towns, and municipalities don't get too involved in barking dog complaints, but there may be a mediation program through the city that you and the barking dog owner can go to try to resolve the issue. That's a possibility. Of course, you both would need to agree to go, and sometimes the dog owner doesn't want to do that. As a dog owner myself, I can tell you that, dogs bark because they're lonely. And so, the owner is probably leaving the dog all day, and there needs to be a pivot so that dog barking isn't driving other neighbors crazy. Have there been any changes to the Arizona election policies or rules? Are the same Arizona regulations that apply to federal, state, and local elections applicable to HOA elections? That's a great question. I hadn't thought about that. There really aren't any. In 2020, there weren't any new laws that were passed. So, basically, the most recent presidential elections and local elections in November of 2020 haven't had any, direct impact yet on HOAs and condos. But I think what we will see is, like I said, there was one bill that is talking about, allowing write-in candidates that we saw in 2020. I think that'll be reintroduced again this year. Also, the right for peaceful demonstrations. I mean, that I think probably is a direct result of what happened in 2020 in the United States. And remember that owners, from years back, maybe 5, 6, 7 years ago, the ability of owners to participate in elections and meetings of the membership by voting by absentee ballot, that's obviously a big change that has been helpful to associations, because if you can't be there in person, you can just return your mail-in ballot. So I hope that answers your question. Stay tuned because, the legislature's in session. You never know what's going to happen. Next question is from Neil. Can the association give a free quarterly assessment due to not being able to open up amenities that were closed since March due to COVID? Lots of unhappy campers who feel they are not getting what they are paying for. That's a common question that we've been hearing since March 2020. We don't recommend that associations stop collecting assessments or give a discount because amenities have been closed, unless the association is in a financial position to do that. I don't know of any associations that have done that, because even though, the pool may have been closed for a while, or some associations haven't reopened their gyms, even though some of those amenities were closed, they still needed to be maintained. The pool still needed to have a pool maintenance company come in and do chemicals. And so the fixed costs that the association had for those amenities didn't change. And remember, as a nonprofit corporation, the association budgets every year for what their expenses are. And even though owners may not have been able to use the pool or may not have been able to use the tennis court or the gym or whatever they're complaining about, we still had to maintain it, and we still had the expenses because they're fixed expenses. So, we aren't recommending it. Very occasionally, an association will lower their assessment rate, but remember, that's a long-term situation. You don't want to be doing that necessarily. So I'd proceed with caution on giving them a free quarterly assessment. Make sure you're reaching out to your trusted advisors and talking about how that might impact your association financially and going forward. Okay, next question is from Robert. Have there been any changes to the Arizona? Let's see, I think that might be the same question twice. I'm going to skip on to the next one. This one's from Anonymous. When you get to the part about virtual meetings, I have a question. What do you do as a manager when the board refuses to do a Zoom meeting and wants to meet in person and not wear masks? Oh my gosh, I'm worried for you as a manager. We actually have had this situation with our firm where right now we're doing virtual meetings. That's basically what we're doing as legal counsel for associations. We need to be responsible. We need to set a good example. But we did have one situation where the board was having a virtual meeting and they wanted us to go out there and set up like a couple days before the meeting so that they could ensure that the meeting was going to go through without any glitches. So when we arrived at the meeting, none of the board members were wearing masks. And so I kind of took note of that. Our team was wearing a mask, but I think it's very okay for us in the industry to tell the boards it's not appropriate to be meeting in person right now. The governor has ordered, that not more than 10 persons should be meeting at any time right now. It's government orders right now. You can't be doing that. We're in the middle of a global pandemic. And as the manager, reminding the board of that and getting your legal counsel involved. And I will tell you, if I'm your legal counsel, I will tell your board you shouldn't be meeting in person right now. It's not a good idea, even if you're outside and even if you're social distancing. We don't recommend it. And so as the manager, I think what you need to say is everybody needs to be wearing masks, and we recommend that you be conducting virtual meetings. And if they refuse to wear masks, I think you need to escalate it up higher in your company that you work for and have somebody higher up in your company reach out to the board and set up ground rules for how the meeting is going to be run. Okay, let's see. Question from John. In scheduling an executive session, which is like a closed session of the board, must the board announce to the general homeowners of a regular meeting that they are going to directly go into a closed session? At the closing of the closed meeting, the board can then come back out and announce to the general homeowners the conclusion of the closed session. So John, great question. So remember, under Arizona law, that the boards are required to announce prior to going into executive session the topics that they're going to be discussing in executive session. That's the law in Arizona. And why is that the law? Because many homeowners felt that the board were going into executive session and discussing non-executive session topics. So as a refresher, typically boards go into executive session to talk about legal advice from their attorney, delinquencies, violations, and problems with the vendor or an independent contractor or an employee of the association. So you are required to announce that. I suggest putting it in the notice of executive session meeting, what topics you're going to be discussing so that you comply with the law. Also announce at the regular board meeting when you go into executive session that you're going into executive session and that the topic that you're going to be discussing. In terms of your comment that the board has the regular meeting, then they go into executive session and they go back into a regular meeting, that's not good planning. Don't do that. You should have your regular meeting and then your executive session meeting, and then it's over, because making owners wait while you go into executive session doesn't make sense. Okay, that's going to make people angry and aggravated, and likely they're going to leave and they're not going to come back for the general session. So don't do it that way. That's just not good planning. Okay, next question is from Stacia. If you send a meeting link to the homeowners to notify them of, like, let's say the Zoom meeting, but of the time of the meeting, and the meeting link changes and only 11 of 160 got the new link, What are the consequences of this? Many owners were left out and the VP asked to postpone the meeting, but the president continued with the meeting. How do we remedy this? Really good question. These are like virtual meeting questions, from being in the trenches, right? So, okay, if your board, well, number one, okay, if you're using Zoom, you should try to always use the same link for the meeting. That's a smart thing to do so that there's not this confusion. And I know it can be done because our firm does it that way. If we have, it's not a recurring meeting, like for our firm meeting, if we're having a Zoom firm meeting, the same link is used. So it's easy for people to connect. So try to do that for your board. Number two, if owners weren't notified of how to come into the meeting, you probably did violate the open meeting law because everybody has to have notice how to attend the meeting. So we're all navigating this, these are challenging times, right? So let's give the president the benefit of the doubt. Maybe there was an emergency that needed to be handled and he or she just wanted to move forward with the meeting to get that done. I'm not saying I agree with it because I don't, but going forward, do it the right way. Try to have the same meeting length for every meeting. Have it on your association's website. So if people can't find the email or how the message was conveyed, if it's in your newsletter, if it's in written form and it's mailed, have it on your website. So it's really easy for people just to click and go and come to your meeting. Remember, we're trying to get people to attend the meeting. We're not trying to keep people from attending because remember, if you have good communication and transparency, integrity, and honesty, you're going to have a lot less problems as a board. If you're hiding things, trying to make it difficult for people to attend meetings, guess what's going to happen? People are going to get angry. You're going to have lots of problems. You're potentially going to be involved in a lawsuit. Trust me, you don't want to do that. So do the right thing. Next question. I had to condense this question a little bit because it was really long. So Arfat is your name. Arfat, thank you so much for sending us a detailed message. If you have any questions after this, you're welcome to email me at bmulcahy@mulcahylawfirm.com. And I'll see if I can answer some of your other questions or be sure to call in our First Friday free call-in. We're kind of going to do some exciting changes on that in the very near future. So stay tuned, everybody. But we offer that service the first Friday of every month. The next one will be in February. Okay, so Arfat's question is, my HOA held an open meeting and let's see, I think I covered most of that already. So I'm going to move on to the next one. Okay, Phoenix Love Neighborhood Association. Okay, thank you for being here. I like the name of that association. Are there some new legalities for the allowance of postponing the annual meeting from what is stated in the HOA bylaws? And can our annual meeting be virtual? So really good question. So we already answered in this presentation today that your annual meeting, not only can it be virtual, but it should be virtual right now due to the ongoing COVID-19 pandemic. So what about new legalities? Like in March and April of 2021, when we were really in the thick of the pandemic and not a lot of people had experience using Zoom, we were telling clients it's okay to postpone having your annual meeting as we figure out how to use Zoom and figure out, some new legalities about how we're going to provide notice and links and getting people up to speed on how to use Zoom. But that time period's kind of over. Okay, like Zoom is the norm now. And so if your documents state that you have to have your annual meeting in March or April, the only way that I would say that you should postpone it is if you don't have enough time to plan it based upon the timeline that you're under. And there's a risk, of course, that an owner could sue you for that. But again, if you communicate really well with your owners and explain what's going on and that there is a plan for the annual meeting and this is when it's going to be, I think that a court is going to be more likely to see your actions as reasonable. So are there any new legalities? Is there any special exemption for 2021 that you don't have to have an annual meeting? No. Do we have to have an annual meeting in 2021 on the date that the bylaws require us to? Yes. If, it's impossible right now, looking at the date in the bylaws to get it done, like let's say that it's January 19th today. Let's say that your annual meeting is supposed to be like the second week in February and you don't even have time to get the notice out, to your owners and get the mail in their absentee ballots back in time. Then reach out to your legal counsel, discuss your options. But my advice would likely be notice it as soon as possible. And then tell the owners why you're not having it on the date that's listed in the bylaws so you have good communication. Please discuss the legality of online voting. So quick primer on that would be that associations are allowed to use online voting. I want to be careful how I phrase this, but I'm not saying online voting in that like there's an email sent to owners and then somebody emails back, yes, I vote for that, like on electing directors. That's not what I'm saying. I'm saying having a plan for the online voting is fine. And state law allows it. So there are companies that handle online voting for associations. They're expensive. So typically the larger master plan communities, like over 5,000 homes, they might hire a company like that to help them run their annual meeting, and every owner is assigned a special password to go in and vote. And we typically do see really high attendance at those meetings, and it's easy to get a quorum when it's done that way. For associations that may not have the legal budget to do it that way, what we recommend is that you still send out your, obviously your annual meeting notice by mail. You're required to do that. Not less than 10, not more than 50 days in advance of the annual meeting under Arizona law. And then you can tell owners, hey, you can return the ballot a number of different ways. You can return the absentee ballot by mail. You can scan it and email it to this email address for the association. But they still have to fill out the ballot, sign it. It has to have the name, the address, the lot or unit number on the ballot. And so they scan it back. They can take a picture of it, email it back to the association's designated email address. Those are all fine under the statute. I even said earlier in the presentation that if you have somebody show up at the annual meeting and they want to cast their ballot, you should have a procedure in place for that. Like maybe they can take a picture of it and email it to a designated person on the board so that it's counted at the meeting. Those are all just really good questions. So we're still having questions on virtual meetings, which is great. And we're still learning on how to be the most effective, in getting a quorum and counting the ballots and letting people vote, in person at the meeting. It's just not in person, like handing the ballot. Now we're using technology to get the ballot to the person that's counting them at the meeting. Next question is from Rosemary. Is an attorney engagement letter for the representation of the board a privileged document, or can it be a request to inspect document? So great question, Rosemary. Okay, so under the law, an attorney engagement letter would be something that is discoverable if an owner makes a records request. The only exception on that is that the prices that the attorney is charging, like their fees, that could be redacted and not given to the owner. Now, if I'm your attorney and I'm advising an association on this, I would say, give the engagement letter, give all the fees, just give them everything on this. We're not hiding anything, right? It is what it is. These are the fees we charge. There's no games here. This is the program. So we recommend that if an owner requests this, we would provide it. Attorneys' bills, though, are a little bit different, because lots of times the bills contain privileged information, and that is not something that we always will give, especially if there's like a detailed analysis of what we're doing on a file. That may not be something that we give to an owner. So that's a little bit different if there's some privileged advice in there, but a fee agreement, that's not privileged, in my opinion. Give it to them. We're not hiding anything. Next question. Our association has a ban on all flags except the U.S. flag, and signs are only authorized during an election with a set time period before and after the election. Will this work? Okay, so number one, a ban on all flags except the U.S. flag is not consistent with what Arizona law says on flying of flags in the association. So if you live in an HOA or a condo, you are entitled to have a number of different flags. So the U.S. flag obviously is one, state of Arizona flag is another one that you're entitled to fly. All of the armed services flags you're entitled to fly. The Indian Nations flags, the Gadsden flag, which is the Don't Tread on Me flag. All of those are protected. And then the political signs, it's a little bit different. There's another law on that. It looks like you're complying with that. So you can only leave the political signs up for a certain time period before and after the election. So you're right, 3 days after the election, the signs would need to be down. So we have a cheat sheet that covers both of these issues. It's our top 10 cheat sheet called the top 10 things you need to know about association law. And that's on our website. It might even be shared in this comment section if we're able to right now. But I would encourage you to look at the deep dive on that in that cheat sheet. Next question, some patios out of 248 units are covered with vega poles. Would they be considered limited common property? Rosemary, I can't answer that unless I see your CC&Rs. So if I were looking at this as an attorney, I represented your association, I would go to the definition section of your CC&Rs, your covenants, conditions, and restrictions. I would look up if there's any definition on limited common property. If it's not there, I'd look in the actual document, the CC&Rs, to determine what's considered limited common property. And it's going to be different for every association. So I can't answer that without seeing your documents. Next question is from Karen. Can you talk about home offices? Oh, I'm so glad you talked about this, because as I was getting ready for this presentation this morning, it's something that I was like, I should talk about that today, because it's probably an issue for 2021. So the question is, can you talk about home offices? And do you have a good definition for CC&Rs regarding this? So I think we need to be lenient on home offices right now during the pandemic, because a great super majority of your residents might be working from home right now because of the pandemic and social distancing requirements, and many companies are virtual right now. So my feeling on it is, I don't know what your CC&Rs say about home offices, but you're going to have some leniency on this right now. The only home offices that are problematic right now would be home offices where there's a lot of traffic coming into the property. Like if it's a home office for, we had a question on this week, as somebody has turned their garage into like a Gold's Gym type of thing, right? Where they've got people out in the street, moving tires and screaming and yelling. And I mean, it's crazy. That is a home business that you would not allow. That's a good example. Or a home business that there's car repair shop in the driveway and the garage and that business, or a chiropractor where there's, people coming in and out. Those are likely not going to be allowed in your CC&Rs, and maybe even under your city or town ordinances. So you're going to have to look at that as you navigate this issue. But the people who are, working from home and they're just dialing in and there's no additional traffic, no additional noise, stay away from enforcing on those people for sure. Next question is from Marty. Could all voting by the membership, such as removal of a board member that requires only those present at the hearing, be allowed by mail? Okay, so I want to just make it clear that anytime you're voting the membership, members need to be allowed to vote either by absentee or mail-in ballot and in person at the meeting. So in person, obviously with virtual, we talked about this a little bit in our presentation. So you can handle the in-person by allowing them to email it once they log on to the virtual meeting to a designated email for the association. You can have a collection box the day of the meeting at the association's common areas. If it's locked, that would satisfy in person for the day of the meeting. So I think maybe what's happening here, it's hard for me to read between the lines on these questions, but maybe you've got like a removal meeting for your association, it looks like, and they are requiring, only those present at the hearing, or maybe they're only allowing voting by mail. They can't do that. The law says you have to allow people to vote by absentee or mail-in ballot. And if they want to vote in person at the meeting, they should be allowed to do so. So your board just needs to pivot and figure out how they're going to handle voting in person at the meeting. Okay, we're at 12:24, so we're doing pretty good on the time. Maybe if somebody could write on the screen how many more questions I have, so I have a good read on it, then I can kind of make sure I'm on good timing here. Okay, the next question is, let's see. Please talk about how a board can communicate using Nextdoor without veering into legal issues, such as a board member speaking for the entire board. Wow, great question. I'm loving the audience participation today. So, okay, Nextdoor, danger zone, right? Okay, Facebook, danger zone. We have a cheat sheet just entirely on this topic, which talks about social media for associations. So just quick thing. The quick piece of advice that I can give you is don't get into fights, disagreements, screaming matches, even though they're all in writing, on these platforms if you're a board. Do not do that. Nobody wins when you do that. How you can make it a win for your community is if there's a Nextdoor chat going on and it's potentially going negative, or a Facebook rant going on, one person on the board who is designated by the rest of the board should post a very simple statement saying, please come to the next board meeting, and information about how you can come to the next board meeting to hear more about the board's position on this topic, period. Do not start fighting with people on these platforms. It's not a win-win, and you can't give all the information, and you're speaking as yourself. You're not speaking as the entire board. So these type of discussions should be done during the regular board meeting. Okay, we have 8 more questions. So the next one's from Veronica regarding the audit requirement per Arizona statute. Our management company has stated that the monthly financial compilation that they prepare monthly satisfies this requirement. Is this true? Tough question. So under the law, and this is on our top 10 cheat sheet that's on our website, it's number 5, right on the bottom of the first page. So every association has to have an audit, review, or compilation every year. So right now, you should be in the stages of organizing your documents so that you can give them to a third party to review 2020, right? And this needs to be done by June 30th, 2021. So what exactly needs to be done? If your association documents require you to have an audit done by a CPA, you must have a CPA do the audit, no exceptions. If your association's documents are silent about having an audit, review, or compilation, which frankly most are, then you just need to look at what the statute says. The Arizona statute that applies to condominiums and to planned communities or HOAs just requires that you do this every year, and doesn't really say that it has to be done according to general accounting principles, right? And so it's loosey-goosey, and it wasn't written very well. So what most associations are doing is the treasurer or a third party will sign something stating that they have done a special review of all the financials and everything's in order. We have a sample form. If you want it, you can reach out to our office. We'll give it to you at no charge. But really just a word of caution. I recommend that you have an audit done by a CPA. Best practices require you, and you have a fiduciary responsibility to act in the best interest of the association. So you should be having checks and balances in place by an independent third party. So your management company shouldn't be checking to make sure that, they did the books right? That's not a good idea. You want an independent person to double check to make sure that you're doing things correctly. And, you can talk with your CPA. You can reach out to our firm if you have any reservations on this. And, we're happy to help you with any, questions that you may have as you determine what is going to be right for your association. 7 more questions. This next one is from Mark. What happens if a homeowner complains about the noise coming from a tennis court they live next to? I love tennis. For some of you who, kind of a fun fact that you may not know about me is that I went to college on a tennis scholarship to Marquette University, and I love tennis. So the sound of a tennis ball hitting is like music to my ears. I absolutely love it. But for some people, it may be something that they don't like to hear. So, usually with a tennis court, it's large enough that if you move into a community, you make a mental note. Okay, hey, there's a tennis court in my backyard, right next to the backyard of my property. There could be noise from the tennis court, right? And so there's probably not much you can do as a homeowner if you're complaining about it. But if it's non-tennis noise, let's say that there's sometimes you see in tennis people who are bad sports and they're screaming and yelling and use bad language. That's a different situation. Then you should be notifying the board, and they should be posting signage and maybe reaching out to the people who aren't behaving and just playing tennis. A question that's totally a lead into this one, which I'm sure some of you might be thinking about, is pickleball. So pickleball is kind of the new hip, fun sport. I play too. I play pickleball, not very well, but I have played pickleball. It's a lot louder than tennis. And people, what they're doing is they're going to the tennis courts and playing pickleball. Or maybe they're bringing lines and plastic lines and putting them on the tennis courts with a temporary net to play pickleball. Pickleball is noisy. I can hear it. Even from where I live, I can hear people playing pickleball, and it's a different sound. It's just a louder, hollow ball sound, and the racket's different than a tennis racket. And so if you're having those issues, you should reach out to your board and talk with them about it. Maybe your board needs to determine whether or not they're going to allow people to play pickleball on those courts versus having people go to actual pickleball court. And we get questions on pickleball all the time, like, should we convert to pickleball? Should we convert our tennis courts to pickleball? It is a hot potato. Reach out to your legal counsel on these issues, because pickleball, for whatever reason, it's one of those things that there's sometimes there are lawsuits, people feel very strongly for or against it. And you want to make sure you have a good legal strategy so that you're making good decisions for your association. Okay, let's see what's the next question from Carlin. The growth of marijuana requires a humid environment, which can cause damage to shared walls in condominiums or townhomes. Is there a way for an HOA to prevent growth of marijuana in their community via the CC&Rs? Okay, this is a really good question. I had a case many years ago, such an interesting case, where the case came into our office from a client because of a strange smell coming from a unit. And, we were sending letters, we were getting ready to file a lawsuit. And then there was an incident that happened where a sprinkler head in the unit, it was a condo, broke and the unit flooded. And there had to be an entry to get into the unit. Under the documents, the association was allowed to do that. And what we found when the door was opened was crazy. What we found was there were marijuana plants growing everywhere. And by everywhere, I mean, I still have the pictures. It was like a jungle. It was a marijuana jungle. And the smell wasn't the marijuana. What the smell was that the owner or the resident, I can't remember if it was a renter or not, they had put dog food everywhere. I mean, like a ton of dog food everywhere, all around the unit. And that was the smell, of course, to cover up the marijuana plant smell. Now, obviously, this was pre-Prop 207. So I guess the next question is, can we as an association prohibit that, the growing of marijuana on your property? So the way Prop 207 is worded is that state law would allow an association or a member to, grow a small amount of marijuana. You have to look at Prop 207 for the actual language on that. That's kind of a new issue. Can the association say you can't grow it? I mean, how are we going to know, right? If it's a small amount, based upon the statute, and they're not growing it as a commercial endeavor or whatever, and they're following what the amount is that you can grow. I think it's going to be really difficult to regulate that. We could look into possibly putting an amendment like that into place. We'd have to look at if it's in a condo, is this considered a change of use, which might require a vote of 100% membership? That's going to need more evaluation. So I'm from a practical standpoint, I'm kind of looking at that thinking, I don't think we want to go there because, they're allowed to do it under the law. How would we even know? It's kind of something that's like, why would we put it in if there's no way we can enforce it? I'm kind of practical that way. So, okay, Amy, next question. What can be done regarding group homes that are not following city ordinances regarding distance, proximity in a community? Are neighborhoods supposed to be notified when these homes are established? So if you do have a situation where you think a group home is in place that is not following city ordinances or county ordinances, reach out to your neighborhood services department or to the code enforcement department at the city that you live in and ask questions. Find out what their position is on this. You'll need to have the addresses of all of the group homes that are in that proximity, and they would be the ones that would regulate that. So are neighborhoods supposed to be notified when these homes are established? It depends on what your CC&Rs say, but best practices would be that the association would be notified by the owner prior to it being, formed. Usually what happens is somebody buys a house and they're doing a lot of renovations on it. And as part of the renovations, you will notice that, hey, this is turning into a group home, and that might be your notification. Or maybe somebody sees advertising, or maybe somebody, there's gossip in the community. Reach out to the owner and get more information on it if that's the case, if you want more information. And our experience on group homes is that people generally really find them to be good owners, and it's not a big problem. Before the group home moves in, there's unrest. People think it's going to change the neighborhood. There's going to be a lot of parking violations. The reality is that we've found that it's not been a problem in this community. So you should know that. If you're faced with this and you want to strategize, reach out to your attorney, our law firm, and we can give you tips from the trenches, having been through that before with many other clients. A homeowner was threatened by our community manager if she used one of our facilities for a homeowner meeting. She would be arrested for trespassing. This homeowner is in good standing, but we are having issues with a discriminating and tyrannical board. Can the office manager enforce this, or does a homeowner have a right to use the facility? This is kind of a hard question because we're in the middle of a global pandemic. So nobody should be having a meeting in the common areas of the association right now, whether it's a clubhouse or wherever. That is not something we're recommending. So if the board is saying, that we're not allowing this, I support the board. But let's go back and look at this. Let's say we're not in a global pandemic and an owner wants to use one of the facilities for a meeting. I guess you need to look at what your documents say. Most owners have a right to use the common areas. And so this may be something that would have to be allowed. Now, I don't know the nature of the meeting, if it's something that would be illegal or inappropriate, we'd have to look further at this. But at first glance, that would be my comments on this. And of course, threatened, I don't know. Anytime somebody threatens another person, you need to talk to, your trusted advisors about what's the best way to handle this. I don't have all the facts, so it's hard for me to comment on that. Can you address home offices, remote working, and do you have a comprehensive definition for this as we are updating our CC&Rs? So I talked a little bit about this on a prior question. I don't have a definition as you're updating your CC&Rs, but I have a suggestion. Reach out to your city, town, or municipality and find out what their ordinance says. That might be something that you'll want to adopt for your community. If it's, too little or too much, then reach out to your legal counsel and see what their opinion is on this. Okay, next question is we only have 2 more questions, which is great. So Deborah asks, we are currently updating our CC&Rs. Will we want to add a section regarding banning smoking marijuana in our common area, which is just a pool area, a ban on all smoking? Or is this for our more casual, non-binding rules and regulations? Okay, so you can put it in the CC&Rs if you would like to. You can put it in your rules and regulations, but rules and regulations are usually not casual and they are usually binding. So, we want to look at what the authority is for you to pass rules. I'm sure, based upon my experience, that you're able as a board to pass rules regarding smoking in a common area. It's going to be easier to get that rule done right now instead of having to go to all the members to, get a membership vote to add it to the CC&Rs. That's probably what I would recommend. And Deborah, remember to take advantage of our 15-minute free review if you haven't already. The association, any association in Arizona who wants our firm to look at their CC&Rs and bylaws, we will do what we call a free 15-minute review and give you suggestions on what things need to be changed. And also we will give you an estimate as to how much we think it will cost to amend the documents so that you can budget for it. And last but not least, we'll let you know if there aren't any changes that are needed and that they're in good shape. Most associations are updating their CC&Rs about once a decade, just as a point from being in the trenches. That's kind of the norm for associations. And if you're one of those associations who's out there and you haven't had your CC&Rs or bylaws amended, and they were written in the 80s, 90s, anytime before 2010, the time is now. You should be doing that right now. So that your documents will stay up to date with what state law says and with the changes and how business is being conducted. Last question is from John. How often should a reserve study be done? Our recommendation is ask your reserve specialist. So, of course, a reserve study is a plan, a strategy, a written strategy for funding your reserve based upon the capital improvements that are needed in your community going forward. And so most association reserve companies will say it's anywhere from every 3 years to every 5 years it should be updated. So reach out to the company that did yours, ask them what their best practices is. If they say every year, I think that's overkill. So then you might want to reach out to one of your other trusted advisors and see what they say. My experience has been it's usually in the 5-year range. Every 5 years, it should be updated. Remember, we have upcoming classes. They're all listed on our website at mulcahylawfirm.com. The different neighborhood services and the virtual HOA Academy is being sponsored here today by the cities of Avondale, Chandler, Glendale, Goodyear, Mesa, Peoria, Scottsdale, Surprise, Tempe, and Queen Creek. And we're going to be extending these classes through June. So once a month, we're going to be meeting via Facebook Live and Zoom. It's always going to be the third Thursday of the month. And we have a really great lineup of classes. So make sure you're tuning in. We'll be sending out lots of reminders, but keep it on your radar for this year. And last but not least, just be sure that you're checking out our Facebook page for our firm, because anytime there's urgent updates that you need to know about, we're posting it typically first on our Facebook page. So be sure to like our Facebook page. It's just under Mulcahy Law Firm PC. And make sure that you're getting the right Mulcahy Law Firm in Arizona. And this will be a great way for you to stay in the know about all things that are happening, urgent things that might be occurring at the legislature or government orders pertaining to the COVID-19 pandemic. So again, I'd just like to thank all of the different cities and towns that have come together to provide this free education for board members, managers, and owners today. Look forward to teaching our next 5 classes over the next 5 months, and also to start planning our classes for the second half of 2021. I hope everybody stays safe during this unusual pandemic time, and continue to make good decisions regarding your associations as you're moving forward. And thank you so much for being here with us today. We appreciate you caring about your communities and taking time to be with us. So look forward to seeing you in the future. Take care of yourselves. Have a great rest of the week.